Hey everybody, Andrew from Pew Brothers. Guys, today I'm so excited. For the first time in quite some time, I get to come to you with something positive as it relates to firearms in the media. Today, the Supreme Court in a 6-3 decision determined that New York State's concealed carry application was unconstitutional because of the application's portion to show proper cause. So those of you guys that don't know, in New York, if you went to go apply for a concealed carry permit or license as they call it, you had to fill out a portion and describe as to why you needed to justify to them why you should have the ability to carry your firearm outside of your home. But thankfully today, the Supreme Court said, unconstitutional. Before jumping any further into my thoughts on this right here, I want to read to you a very powerful opinion wrote by Justice Thomas. Justice Thomas reflects back on a precedent found in 1857 in the Dred Scott versus Sanford case. Now, this is powerful. It's powerful in a lot of different reasons, and we'll get to those here in a second. But I'm going to put it up on the screen for you, and I'm going to give you just some of the cliff notes from here. Justice Thomas starts off with, a short prologue is in order. Even before the Civil War commenced in 1861, this court indirectly affirmed the importance of the right to keep and bear arms in public. Writing for the court in Dred Scott versus Sanford, Chief Justice Taney offered what he thought was a parade of horribles that would result from recognizing that free blacks were citizens of the United States. If blacks were citizens, Taney fretted, they would be entitled to the privileges and immunities of citizens, including the right to keep and carry arms wherever they went. Thus, Chief Justice Taney recognized, albeit unenthusiastically in the case of blacks, that public carry was a component of the right to keep and bear arms, a right free blacks were often denied in antebellum America. Ladies and gentlemen, the precedent that was established then is that the Second Amendment not only allows us to keep and bear arms, but keep and bear those arms in public places. It also highlights that it is recognized that if a population of people are lawfully, at least in Justice Taney's eyes, lawfully prohibited from possessing firearms, that they can be suppressed. In 1857, the United States, through systematic means as this, knew that they could keep black individuals suppressed longer, keep them more manageable, so long as they limited their access to firearms. 1857. Today, the population, although different, has increased to everyone. I would strongly encourage you, if you don't already, to own a firearm. The court then, Justice Taney, Chief Justice Taney, he knew that if free blacks were granted citizenship, they wouldn't stand for it. They would go up in arms against the government for being treated the way that they were being treated. He knew that they would rebel. Let's move forward. We see that all of us today as citizens can look at the government and say, hey, maybe there's some suppression activities that are on the chart boards. I'm not going to be a conspiracy theorist, but if it was true in 1857, I don't think the mentality and mindset of controlling bodies of government such as the United States could think differently now. If we used firearms to control individuals then, isn't it reasonable to think that we could use them, or their lack of use of them could be used to control them now? Just think about that. I think that Justice Thomas's opinion was penned so tactfully, so well constructed, He referenced upon a time when we suppressed an entire population of people and understood that these population of people would be entitled to rights and immunities such as not only keeping and bearing these arms, but carrying them with them in public places. Justice Thomas got this right. And this 6-3 dissent, this 2/3 of the Supreme Court that held this, I think this is the Supreme Court we've been looking for. I'm excited for this to come out to set this president moving forward so that we can reflect upon this as we continue our fight for freedoms of firearms here in our nation. I want to end off with this right here, and this is the other school of thought that comes into play with this. Justice Alito, and I'm so glad that this was included in there. It's kind of what we all say, that gun laws don't stop anyone. Here we go. Justice Alito in his concurrence says, and how does the dissent account for the fact that one of the mass shootings near the top of its list took place in Buffalo? The New York law at issue in this case obviously did not stop that perpetrator. In our nation's highest court, Justice Alito, in paraphrases, said, laws don't stop bad people. Good guys and girls with guns stop bad people. Guys, thanks for tuning in to Pew Brothers today. Glad you came and watched this video. I hope you're as excited as I am. I hope we see a lot of change on the horizon, both on the federal and state level. It's looking up. I'm not going to get too optimistic, but it's looking up. Thanks for watching Pew Brothers. Make sure you subscribe, ring that bell down below, and as always, plink responsibly.